$847,000. That's what our business was worth the week I found out I didn't legally own a single dollar of it. Not the building, not the client list, not the 11 employees who called me boss for 4 years, not the brand I built from a card table in my apartment into a company that grossed 7 figures annually. None of it. Because 3 years earlier, on a Tuesday afternoon while I was in the hospital recovering from emergency surgery, the man I trusted more than anyone on earth walked into a lawyer's office and filed paperwork that made him the sole owner of the company we built together. My name wasn't on the articles of organization. My name wasn't on the EIN registration. My name wasn't on a single bank account, a single vendor contract, a single piece of paper that mattered. For 3 years, I ran that business. I signed the leases, but his signature was on them, too, listed as managing member. I hired the staff, but his signature was on the offer letters. I built the client relationships, but the contracts said the services were rendered by an entity I had no legal claim to. He thought he'd been careful. He thought hospital rooms and morphine drips and a fiancé who trusted him completely were the perfect cover for what he was doing 3 floors down in a strip mall law office. He was wrong. Because 3 years later, I didn't just get my company back. I got a forensic accountant, a business litigation attorney, and eventually a criminal fraud investigator from the district attorney's office involved. And when it was over, the man who thought he'd outmaneuvered me was staring down felony charges, a 7-figure judgment, and the complete public unraveling of the life he built on my labor. This is the story of how he did it, and exactly how I took it all back. They thought they got away with it. They were wrong. Hey everyone, welcome back to the channel. If this is your first time here, this is where I tell true financial revenge stories, real accounts of people who got scammed, defrauded, or betrayed by someone they trusted, and then fought back and won. Today's story is about greed, betrayal, and getting every single dollar back. It involves a small business, a hospital bed, a secretly filed LLC, and one of the most methodical legal takedowns I've ever covered on this channel. Before we get into it, if you're new here, hit subscribe because these stories only get more unbelievable and I post a new one every week. If you've been scammed or betrayed financially yourself, stick around to the end because I want to hear your story in the comments. Now, let's talk about how a man named Derek Holloway tried to steal a business out from under the woman who built it, and how she made sure he paid for every single cent. My name is Sarah. I'm changing some identifying details in this story for legal reasons, since parts of this case are still winding through the court system, but everything that happened here happened. In 2019, I was 31 years old, working as an event planner for a mid-sized firm in the Midwest, making about $58,000 a year. I was good at my job. I was, if I'm being honest, better than good. I had a client list that followed me from firm to firm, a reputation for delivering flawless corporate events on impossible timelines, and a growing sense that I was making someone else rich while I sat in a cubicle. That's when I met Derek. Derek was a contractor, audio-visual production, the guy who showed up with the sound systems and the lighting rigs for the events I planned. He was charming in that easy, confident way that either makes your guard go up immediately or disappear completely. Mine disappeared. We started dating in the spring of 2019. By that summer, we were talking about starting a company together, an event production business that would combine my planning and client relationships with his technical production skills. It made sense. It made so much sense that I didn't stop to ask the questions I should have asked. Here's the first thing I want you to notice, because if you've watched this channel before, you already know where I'm going with this. Derek was the one who suggested we form an LLC. Derek was the one who said he knew a guy, a business attorney he'd used for a previous venture, who could get the paperwork done quickly and cheaply. Derek was the one who handled all the boring legal stuff so I could focus on what I was actually good at. If you are watching this and you are currently building a business with a partner, a spouse, or a significant other, and one person has quietly become the one who handles all the paperwork, I need you to pause this video right now and go check your Secretary of State business filings. I'll wait. This story is about to show you exactly why that 5 minutes of checking matters more than almost anything else you'll do this year. We formed Holloway House Productions. Yes, his last name was in the company name, something I brushed off at the time as branding because Derek said Holloway sounded more upscale than my last name, and we needed a name that would test well with corporate clients. Looking back, that should have been red flag number 1. It wasn't just branding, it was the first brick in a wall he was building around a company he intended to keep entirely for himself. In August 2019, we drove to the attorney's office, a small practice above a dry cleaner run by a man named Gary Feldstein, who, as I'd later learn, had done exactly one other business filing in his career that wasn't a straightforward divorce or will. Derek did all the talking. I sat in a chair in the corner, tired from a 60-hour work week, and I signed where Derek told me to sign. I did not read the articles of organization line by line. I want to be honest about that, because this is the part of the story where people watching at home might feel a flash of judgment. How could she not read the document? And I want to meet that head on instead of pretending it didn't happen. I trusted him. We were engaged by that point. We'd talked about kids, about a house, about growing old together. I signed a stack of papers he told me were standard LLC formation documents, basically identical for both of us, because why would the man I was about to marry lie to me about something like that? Here's what those documents actually said, word for word, which I would only discover 3 years later. Derek Michael Holloway, sole managing member. My name appeared exactly once on page 4 in a single clause describing me as a non-member contractor providing event coordination services to the company. Not a founder, not an owner, not a partner, a contractor. We built that business from nothing. In year 1, we grossed $210,000. By year 2, $480,000. By year 3, the year everything fell apart, we were on pace to clear $1.1 million, with 11 full-time and contract employees, a leased 4,000 square foot warehouse and office space, 3 box trucks, and a client roster that included 2 Fortune 500 regional offices and a hospital system's annual gala. Every ounce of that growth ran through my Rolodex, my reputation, and my 60 to 70-hour work weeks. I was the face of the company at every single client pitch. My photo was on the website under Founder and Creative Director. My name was on the trademark filing for the logo. Derek let me have that one, and now I understand exactly why. A trademark isn't the company, it's decoration. It doesn't come with a bank account or a lease or the legal authority to sell the business out under someone. The money moved through a business checking account at a regional bank. Derek was the primary signer. I was listed as an authorized user, a designation that I'd later learn from my attorney gives you access to move money but zero legal ownership claim to the account itself. I didn't know that distinction existed. Most people don't until it's too late. We got married in the spring of 2021. The business was, by every outward appearance, a shared triumph, the thing we'd point to at dinner parties as proof that we were a team, that we built something real together. Derek would tell the story at every networking event. We started this with a card table and a dream. He said we constantly. He said we in front of clients, in front of employees, in front of his own family. He never once in 3 years said the word I when it came to ownership, because saying I out loud before he was ready would have tipped his hand too early. There were other red flags, small ones at the time. Derek insisted on being the one who dealt with our accountant every quarter. I'd get a summary, never the actual filings. Derek insisted on handling all vendor negotiations for anything over $10,000, which conveniently included the warehouse lease, the truck leases, and our equipment financing, all of which, I'd later learn, were structured entirely in his name and the company's EIN, an EIN that listed him as the sole responsible party. Derek would occasionally get cagey when I asked to see the full P&L instead of the summary, always with a reasonable-sounding excuse. I don't want you stressing about the numbers on top of everything else you're managing, or Our accountant is slow getting me the full reports this quarter. I remember one specific dinner conversation, maybe 8 months before everything came apart, where I said, half joking, we should probably update our operating agreement to reflect actual ownership splits, right? 50-50, since we've never formally divided anything. Derek laughed and said, baby, we're married. Everything's 50-50. You want to pay a lawyer $2,000 to tell us what we already know? I let it go. That sentence, you want to pay a lawyer $2,000 to tell us what we already know, would end up being one of the most expensive sentences of his entire life, because 18 months later, I would spend considerably more than $2,000 to have a lawyer tell me exactly what I didn't know. The moment everything changed came in March 2022. I had a severe gallbladder attack that required emergency surgery, a laparoscopic cholecystectomy, 4 days in the hospital due to complications, followed by 6 weeks of limited work capacity. I was on painkillers, exhausted, scared, and entirely dependent on Derek to keep the business running while I recovered. And that's when I found the smoking gun. Except I didn't find it then. That's the cruelest part of this story, and I want to be honest with you about the timeline, because it makes what came later so much more devastating. I didn't find anything in that hospital bed. I trusted Derek completely while I was recovering. I had no idea that while I was under anesthesia on a Tuesday morning, Derek was sitting in Gary Feldstein's office 3 miles away, filing a certificate of amendment that formally removed the last vestiges of ambiguity about my role in the company, reclassifying me in the state's business registry purely as an independent contractor providing services to H. Holloway House Productions LLC, with 0 ownership interest, effective immediately. I found out about that filing 18 months later, but that hospital bed, that moment of total vulnerability, that's when he made his move. He filed it in the exact window he knew I couldn't check, couldn't question, couldn't even get out of bed to drive to the county clerk's office. He filed it while I was still groggy from surgery, while flowers he'd bought me were still sitting on the nightstand, while he was telling nurses and visiting coworkers what a devoted husband he was. That's who I was dealing with, not a man who made a mistake, a man who planned. For the next year and a half, life looked normal. The business kept growing, we moved into a bigger house. Derek bought a truck, a $71,000 truck, paid for, he told me, through the business, which I now understand meant it was financed under the company's IEN with him as sole guarantor, an asset that legally belonged to an entity I had no ownership stake in, purchased with revenue I had personally generated. The cracks started showing in the fall of 2023. Small things first. Derek became evasive about scheduling. Client calls I used to be on, I was suddenly excluded from, so you can focus on production, not admin. He started taking meetings with our accountant alone, then with a second accountant I'd never met, then eventually with someone he introduced only as a business consultant, who I later learned was actually a business valuation specialist, the kind of professional you hire when you're preparing to either sell a company or push someone out of it. In October 2023, I asked to see the operating agreement, just to read it out of curiosity because a friend of mine had recently gone through a business divorce and it made me think about our own paperwork for the first time in years. Derek told me he'd dig it up and get back to me. He didn't. I asked again in November. He said our accountant had the only copy and she was swamped with year-end stuff. I asked a third time in December. That's when he got angry, genuinely, disproportionately angry, the kind of reaction that in hindsight was the loudest red flag of the entire relationship, because innocent people don't explode when their spouse asks to read a document. "Why are you suddenly so worried about paperwork?" he said. "Do you not trust me?" I want to talk directly to anyone watching this who has experienced that exact conversation, where you ask a completely reasonable question about shared finances, and instead of an answer, you get anger, deflection, or guilt tripping. That reaction is data. Write it down. Remember it. Because when someone weaponizes your trust in them as a reason not to verify basic facts, they are usually counting on that trust to keep you from ever verifying anything at all. By January 2024, I stopped asking Derek directly and started asking around. I called Gary Feldstein's office, the attorney who'd formed the LLC back in 2019, and asked for a copy of our operating agreement and articles of organization, since I was, after all, a member of the company we'd formed together. Gary's paralegal put me on hold for what felt like 10 minutes. When she came back, her voice had changed. She said she'd need to check with the firm's ethics counsel before releasing any documents, because their client of record was Derek Halloway individually and Halloway House Productions, LLC, and she wasn't authorized to confirm or deny who else might be listed on the filings without checking first. That sentence, "I'm not authorized to confirm or deny who else is listed," is when the floor dropped out from under me. Because if I were a member of that LLC, there would be nothing to check. Members are entitled to their own company's records, full stop, in virtually every state in the country. The fact that a paralegal needed to check with ethics counsel before telling me, the person who built the company's entire client base, whether or not I was legally part of it, that told me everything I needed to know before I ever saw a single document. That night, I did what I should have done 5 years earlier. I went to my state's Secretary of State Business Search Portal, a free public database available to literally anyone with an internet connection, and I typed in Halloway House Productions, LLC. The filing came up in less than 2 seconds. Registered agent, Derek M. Halloway. Organizer, Derek M. Halloway. Managing member, Derek M. Halloway. Members listed, 1. My name did not appear anywhere on the document, not as a member, not as a manager, not as an owner of any percentage of any kind in any capacity. I sat at our kitchen table at 11:47 p.m. on a Tuesday night in January and read that filing 4 times, certain I was misreading it, certain there had to be a second document, a side letter, something that recognized what I actually was to this company, its co-founder, its creative director, the person whose name and reputation had closed the deal on literally every single major client we had. There was nothing. I checked the state's UCC filing database next and found that our equipment financing, nearly $180,000 across 2 loans, listed Derek as the sole personal guarantor and Halloway House Productions, LLC as the debtor, with no mention of me in any capacity. I checked our warehouse lease, which I pulled from a folder in our home office while Derek was out. The lease was signed Derek M. Halloway, managing member, with no secondary signature line for me at all, not even as a guarantor. I checked our business bank accounts next through the online banking app I'd used for years to pay vendors and run payroll. I logged in and, for the first time, actually read the account agreement documentation instead of just the transaction history. Primary account holder, Derek M. Halloway. Authorized signer, Sarah. Authorization level, transactional only, no ownership designation. Every single asset, every account, every lease, every loan, all of it structured the exact same way, for 5 years, in plain sight, hidden behind nothing more sophisticated than the simple fact that I never checked. I want to pause here and talk about the scale of what this actually meant, because "he didn't put my name on the paperwork" can sound abstract until you do the math. By January 2024, Halloway House Productions, LLC had annual revenue of approximately $1.1 million, a client contract backlog worth an estimated $640,000 over the following 12 months, physical assets, trucks, production equipment, warehouse build-out, appraised later by a forensic accountant at $312,000, cash reserves of roughly $94,000, and a brand and client list that a business valuation expert would later value, as a going concern, at approximately $847,000. I had personally generated, by conservative estimate, using time tracking and CRM records I still had access to, somewhere between 70 and 80% of the client relationships that produced that revenue, and legally I owned 0% of any of it. I confronted Derek 3 days later, on a Friday evening, after I'd had time to gather myself and, frankly, after I'd already made a phone call I'll tell you about in a moment. I asked him directly, "Why isn't my name on any of the business filings?" Derek's face did something I will remember for the rest of my life. A half-second flash of pure panic, gone almost instantly, replaced by a practiced, patient smile that I now recognize as the same expression he used on nervous new clients during a sales pitch. "Baby, it's just a formality," he said. "You know everything is ours. I handled the paperwork because I understood the legal side better, that's all. If you want, I'll add you to everything this weekend." That offer, "I'll add you to everything this weekend," was, in hindsight, its own kind of confession, because if I had truly been a co-owner this entire time, there would be nothing to add. You don't add someone to something they already own. I didn't say any of that out loud. I said, "Okay, let's do that." And I smiled back at him because I had already made a decision 2 days earlier that I wasn't going to tell him about yet. I'd already called an attorney. Her name was Renata Okoffer, a business litigation and family law attorney recommended to me by a friend who'd mentioned almost in passing that Renata specialized in a very specific and apparently not uncommon category of case: spouses or romantic partners who build a business together only for one partner to secretly structure the entity to exclude the other. Renata told me in our first 15-minute consultation call a sentence I will never forget. "What you're describing has a name in family and business law circles. We call it entity shielding, using a business structure to functionally disinherit a spouse or partner from an asset they helped build. I've handled 6 of these in the last 4 years. Every single one was winnable if the client had documentation of their contributions. Do you have documentation of your contributions?" I told her about the CRM system with 5 years of client interaction logs under my name. I told her about the email trail. I told her about the marketing materials with my name and title on them, the vendor contracts I'd personally negotiated even if I didn't sign them as an owner, the awards the business had won that were accepted on video by me. I told her about the trademark registration for the company logo, which, because Derek had let me handle it, was filed under my name alone. Renata went quiet for a second, then said, "Okay, that trademark is actually going to matter a lot more than you think. Don't tell your husband you've spoken to me. Don't confront him again yet. I need you to start gathering documents this week, quietly, before he has any reason to think about covering his tracks further. Can you do that?" And that's when I found the smoking gun, except this time it wasn't one document, it was the beginning of a paper trail that would take 3 months to fully assemble, and that would ultimately prove not just that I'd been excluded from ownership, but that Derek had been actively, deliberately concealing the truth from me for years, including, as I'd soon discover, during the very week I was recovering from surgery. Because here's what I didn't know yet on that January night. The 2022 hospital bed filing, the one that formally reclassified me as a contractor while I was under anesthesia, I hadn't found that one yet. That discovery, and how much worse it made everything, was still 3 weeks away. Renata's instructions were specific, methodical, and frankly, the best crash course in evidence gathering I've ever received. Over the following 6 weeks, while pretending to Derek that our marriage and our business were both completely normal, I became a detective inside my own life. Step 1. Preserve everything digitally off-site. Renata had me set up a personal cloud storage account unconnected to any device Derek had access to, and had me systematically download and back up every piece of documentation I could access without raising suspicion. 5 years of CRM export data showing every client interaction I personally logged, every email where I was CC'd on client negotiations, every marketing asset with my name and title, every social media post, ours and clients, that referred to me as co-founder or owner, every performance review I'd given employees, and every tax document I could locate, including the K-1 forms. The K-1 forms were, in Renata's words, the single most important document in this entire case. A K-1 is the tax form an LLC issues to each of its members, reflecting their share of the company's profit or loss, which they then report on their personal tax return. If I had never received a K-1, if only Derek had ever received one, that was powerful evidence that, in the eyes of the IRS as well as the state, I had never been treated as an owner. I found 5 years of our joint tax returns in a fireproof box in our closet. I photographed every page with my phone over the course of 3 separate evenings while Derek was at the gym. Sure enough, every single year, Schedule K-1 for Halloway House Productions LLC issued to Derek M. Halloway alone. Every single year, our joint return reported that K-1 income as his, not ours, his. Step 2. Reconstruct the ownership narrative through everyone else's records. This is the part of the investigation that genuinely surprised me. How much evidence of my ownership existed in places entirely outside Derek's control. Our commercial insurance policy, for instance, the general liability and equipment policy covering the warehouse and trucks, listed Sarah, co-owner, as an additional named insured. Because 5 years earlier, when we set the policy up together, the insurance broker had simply asked both of our names and titles and typed what we told her. Derek had never gone back to correct it. That single line item, buried in an insurance policy neither of us had looked at in years, became one of the most powerful pieces of evidence in the entire case, because it was third-party documentation, created by someone with no stake in the outcome, that both of us had, at the time, represented me as a co-owner. I found similar gold in our commercial vehicle registrations with the state DMV. One of the 3 box trucks was registered with me listed as a co-owner on the title, a paperwork inconsistency from a truck we'd purchased together at a dealership in year 2, before Derek had fully tightened up his system. I found it in a Small Business Administration loan application from 2021, an SBA loan we'd applied for, which Derek had filled out and had me sign as co-owner, 50% ownership interest, because, at the time, claiming 2 owners with 50-50 ownership actually helped our loan eligibility. That document, signed under penalty of federal perjury statutes, stating I owned 50% of the company, sitting in an SBA database, would become one of Renata's favorite exhibits. Step 3. The forensic accountant. In February 2024, Renata brought in a forensic CPA named Michael Tran, who specializes in business valuation and asset tracing in litigation contexts. Michael's job was twofold. First, to establish a defensible valuation of what the business was actually worth, and second, the part that made my stomach turn, to trace exactly how much of the company's cash flow over 5 years had been diverted toward Derek personally versus reinvested in the business or distributed to both of us. What Michael found took 3 weeks to compile into a report, but the headline numbers were staggering. Over the 18 months prior to my discovery, Derek had been quietly increasing his personal owner's draws from the business, a completely normal thing for a business owner to do, except he was the only person the business's books recognized as an owner. In that 18-month window alone, Derek had drawn $186,000 in distributions, on top of a $95,000 salary he paid himself through the company payroll, a salary that, again, only he received. My compensation, all 5 years, had been structured as a 1099 contractor payment, capped at levels that kept me well below what my actual client generation was worth to the business. And that's when I found the smoking gun. Michael's report also uncovered something I hadn't expected: a series of transfers in late 2023 totaling $140,000 moved from the business operating account into a new personal brokerage account Derek had opened, one I had never seen, at an institution we didn't otherwise bank with. The timing was not a coincidence. Those transfers began almost exactly 2 weeks after the business consultant, the valuation specialist Derek had brought in without telling me the real purpose, had delivered a preliminary valuation of the company. Derek wasn't just hiding ownership from me. Derek was actively preparing an exit. He was liquidating cash out of the business into an account I had no visibility into, positioning himself to either sell the company outright or to walk away from the marriage with the business's liquid assets already moved somewhere I couldn't touch them in a divorce. Renata's read on this, when she saw Michael's report, was blunt. He's not just trying to keep the business. I think he's planning to leave you and take the money with him before you even know there's anything to fight over. That's when we found the hospital filing. Renata had requested the full filing history for Holloway House Productions, LLC from the Secretary of State's office, not just the current active filing, but every amendment ever submitted, going back to 2019. It came back as a stack of documents, and buried in the middle of it was a certificate of amendment dated March 15, 2022. I didn't need to check my own records to know what that date meant. I remembered it instantly, the way you remember dates tied to physical pain. March 15, 2022 was the day after my gallbladder surgery. I was still in the hospital. I have photographs on my phone, time-stamped, of myself in a hospital bed that exact afternoon with Derek's mother visiting, bringing me soup, while, according to the filing's submission timestamp, Derek was 3 miles away at Gary Feldstein's office signing an amendment that formally stripped away any lingering ambiguity about my status, reclassifying me purely as a contractor. I sat in Renata's office when we found that filing, and I did not say anything for almost a full minute. Renata let me sit with it. Then she said quietly, "This is the moment this stops being a business dispute and starts being something a prosecutor might be interested in. Filing corporate paperwork to strip Astause's ownership interest, timed to a moment when you knew she was medically incapacitated and unable to object or even be aware. A lot of DAs would call that a deliberate, aggravating act. It speaks to intent in a way that helps us enormously." Step 4. Going wider. Renata recommended we also file a complaint with the State Attorney General's Consumer and Business Protection Division, since Derek's conduct, misrepresenting business ownership to a spouse who was actively investing labor and, in earlier years, personal savings into the company, touched on issues the AG's office had jurisdiction to investigate, separate from our civil case. She also connected me with a business fraud detective in the county DA's Economic Crimes Unit, a woman named Detective Patricia Ruiz, who had handled several cases involving exactly this pattern, a partner using corporate formation documents as a tool of financial control and eventual theft. Detective Ruiz was cautious at first. These cases are notoriously hard to prosecute criminally because so much of what happens between business partners, even bad faith conduct, falls into civil rather than criminal territory. But when she saw the hospital bed filing date, combined with the $140,000 in transfers to an undisclosed brokerage account, her tone changed. That timing detail, she told me directly on a recorded call I kept with Renata's guidance and full legal compliance with our state's single-party consent recording laws. That's not just bad behavior. If we can show he deliberately structured that filing to exploit a period when you were medically unable to review or object to it, that starts to look like it could support charges under our state's fraud statutes, possibly even elder or vulnerable person financial exploitation provisions, depending on how the DA's office wants to charge it, given the medical incapacitation angle. There was one more near miss before we were ready to move. In early March 2024, about 6 weeks into the investigation, Derek came home unusually early one afternoon and found me on a video call with Michael Tran, our forensic accountant, a call I'd taken in our home office believing Derek was at a client meeting until 6 p.m. I minimized the screen fast enough that he only saw the tail end of a spreadsheet, but he asked, with unmistakable suspicion in his voice, "What was that? Who was that?" I told him it was a friend helping me look at freelance tax deductions, a lie I'd rehearsed with Renata precisely because she'd warned me this exact scenario might happen. Derek seems to accept it, but that night our home Wi-Fi router mysteriously needed a firmware update that Derek insisted on doing himself, and I later found, when I mentioned it to a tech-savvy friend, that a new device, a personal VPN service, had been installed on our shared family laptop the very next day. I believe, though I can't prove definitively, that Derek was starting to get nervous and may have begun trying to monitor or obscure his own digital activity in response. Renata's advice was immediate and firm. We move up the timeline. We're filing within 2 weeks, not 2 months. If he's getting spooked, we cannot risk him moving more assets or, frankly, destroying records. On March 22, 2024, Renata filed a civil complaint on my behalf in state court, alleging breach of fiduciary duty, unjust enrichment, constructive trust, and fraud, and simultaneously filed for a temporary restraining order, freezing the business bank accounts and the undisclosed brokerage account to prevent further asset dissipation while the case proceeded. 2 days later, Detective Ruiz's office executed a record subpoena on Gary Feldstein's law firm and on the bank holding the brokerage account, formally opening a parallel criminal fraud investigation. Derek was served with the civil complaint and the TRO paperwork on a Tuesday morning at the warehouse in front of 2 of our employees. I wasn't there when it happened. Renata called me 40 minutes later and said, "It's done, he's been served. The accounts are frozen as of this morning. Now we wait and see how he reacts. But Sarah, I need you to understand, from this point forward, this is no longer something you can undo by staying quiet or being patient. This is happening one way or the other." Derek's first reaction, according to 2 employees who witnessed it, was to demand to know if I had lost my mind. His second reaction, about 90 minutes later, once he'd actually read the complaint and realized the frozen accounts included both the business operating account and the previously undisclosed personal brokerage account, was to call his own attorney, not Gary Feldstein, whose limited litigation experience was suddenly glaringly inadequate, but a business defense attorney named Robert Kessler, whom he apparently found through a hasty Google search that afternoon. The next 8 months were, without exaggeration, the most stressful and also the most empowering period of my adult life. I want to walk you through how it actually resolved, because the process matters as much as the outcome. This wasn't a single dramatic courtroom moment, it was a grinding, methodical war of attrition, fought almost entirely through depositions, financial disclosures, and the slow accumulation of undeniable evidence. The deposition. In June 2024, Derek was deposed for 11 hours across 2 days. Renata walked him document by document through every filing bearing only his name, every K-1 issued solely to him, every insurance policy listing me as co-owner that he'd never corrected, and finally the March 15, 2022 amendment filed while I was hospitalized. Renata asked him directly, on the record, why he'd chosen that specific date to file that specific amendment. According to the transcript, Derek's attorney tried to instruct him not to answer, citing attorney-client privilege regarding conversations with Gary Feldstein about the filing's timing. Renata pushed back, correctly, that the fact of the filing date and the fact of my hospitalization were not privileged information, only conversations with counsel were, and the judge, in a later hearing on a motion to compel, agreed, ordering Derek to answer the factual question of whether he knew I was hospitalized and medically incapacitated at the time he executed the filing. He admitted it. Under oath, he admitted he knew I was in the hospital recovering from surgery. He admitted he filed the amendment that same day. When asked why, he said, and this is a near exact quote from the certified transcript, one Renata later described to me as the sentence that won us the case, he said, "I wanted to get the paperwork cleaned up while things were quiet." Things were quiet because I was under anesthesia. The valuation battle. Derek's attorney tried to argue the business was worth far less than Michael Tran's assessment, around $310,000, they claimed, disputing the goodwill and client relationship value that made up the bulk of Michael's $847,000 figure. This is an extremely common defense tactic in business valuation disputes. Undervalue the intangible assets, especially the ones tied to relationships and reputation, because they're harder to pin down than a truck or a warehouse lease. Michael's counter was devastating and frankly beautiful to watch unfold in the mediation session I attended. He walked through 5 years of CRM data showing that of the 11 active corporate clients generating recurring revenue, 9 had their primary point of contact logged as me, not Derek. He showed client satisfaction surveys, routine ones we'd run for years, where clients specifically named me by name as the reason they continued working with the company. He calculated, using standard industry methodology for goodwill valuation in professional services businesses, that client relationships I personally built and maintained represented no less than 68% of the company's enterprise value. All told, between the direct settlement payments, the released brokerage funds, and the value of the business ownership itself, the total financial resolution came to just over $1.03 million. And Derek's own expert, under cross-examination during a mediation deposition, ultimately conceded that his $310,000 figure hadn't adequately accounted for what's called personal goodwill, tied specifically to me as an individual, a legal concept that in several states is treated as a distinct and separately allocable asset in exactly these kinds of ownership disputes. The criminal side. While the civil case moved through discovery and mediation, Detective Ruiz's investigation was proceeding in parallel. In September 2024, the county DA's office formally filed criminal charges against Derek, 1 count of fraud in the second degree related to the SBA loan application, the one where he'd had me sign as 50% owner to strengthen the application, then subsequently structured the entity to deny that exact ownership, which prosecutors argued constituted federal loan fraud, since the ownership representation made to the SBA was knowingly false at the time it was submitted, or alternatively knowingly false at the time he later stripped my ownership while letting the loan representation stand uncorrected. Additionally, prosecutors filed 1 count of exploitation of a vulnerable person tied specifically to the March 15, 2022 filing, under a statute typically used for financial exploitation of hospitalized, elderly, or medically incapacitated individuals, a provision Detective Ruiz had flagged as applicable given my documented surgical incapacitation at the precise moment of the filing. Derek's criminal attorney pushed for a plea deal almost immediately once the SBA fraud angle became public record, since federal loan fraud, even when charged at the state level in connection with a federally backed loan, carries the kind of exposure that makes defense attorneys move fast. In November 2024, Derek accepted a plea agreement, guilty to 1 count of fraud in the second degree, with the exploitation charge dismissed as part of the negotiated plea, in exchange for a sentence of 18 months with all but 90 days suspended, 5 years of probation, mandatory restitution, and a permanent bar from serving as an officer or managing member of any registered business entity in our state for a period of 10 years. 90 days. It wasn't the years I'd fantasized about in my angriest moments during those 8 months, but Renata reminded me of something important. The criminal case was never going to be the whole win, its leverage, its accountability. The real financial justice happens in the civil case, and the plea, on the record, is now something we can use there too. She was right. The civil settlement. With Derek now a convicted felon on a fraud charge directly tied to the business's formation and ownership representations, his negotiating position in the civil case collapsed. In January 2025, roughly 10 months after the complaint was filed, we reached a settlement. Derek agreed to transfer 100% ownership of Holloway House Productions LLC to me, retroactive to the original 2019 formation date, effectively erasing his ownership from the company's legal history entirely. He agreed to pay $310,000 in direct compensation for 5 years of underpaid contractor wages relative to fair market value for my role, based on Michael Tran's analysis. The frozen brokerage account, the $140,000 he'd quietly siphoned out in late 2023, was released in full to me as part of the settlement, treated as an advance recovery of misappropriated business funds, and critically, Renata secured a clause requiring Derek to personally cover $85,000 of my legal fees, on top of everything else, as a condition of settlement rather than risk trial. Value returned to me, against a company Derek had tried to convince me for years was never legally mine at all. The twist, what the money was actually for. Here's the part of this story that even now makes my stomach turn more than the fraud itself. During discovery, we learned what Derek had actually been planning to do with that $140,000 brokerage account, and with the business sale he'd been quietly exploring with a broker in late 2023, the same period he brought in that business consultant for evaluation. He wasn't just planning to leave the marriage and keep the business. Text messages produced in discovery, exchanged with a woman he'd been in an undisclosed relationship with since mid-2023, revealed the plan explicitly: sell the business for an estimated $700,000 to $900,000, quietly divorce me with the company already excluded from marital assets since it was never ours on paper, and use the proceeds to fund a relocation and a new life, including, in one particularly gutting message thread, browsing listings for a beachfront property in another state, a home he referred to in one text as our fresh start once the Sarah situation is handled. The Sarah situation. 5 years of my life, reduced to a line item to be handled before he could fund a new life with someone else, using money generated almost entirely by my work. I'm not going to pretend that finding those messages didn't hurt in a completely different way than the financial fraud did, but I will tell you this. By the time I read them, sitting in Renata's office, with the settlement already largely negotiated, I didn't cry. I remember feeling something closer to clarity. Every ounce of guilt I'd carried, the nagging voice asking whether I was somehow overreacting, whether this was really theft or just a messy business dispute between two people who loved each other, evaporated completely. This was never a mistake. It was a plan, executed patiently over years by someone who had decided, probably long before I ever suspected anything, that I was an obstacle to be managed rather than a partner to be honored. Where things stand now. Halloway House Productions is mine, fully on paper and in reality, for the first time in its history. I changed the name within a month of the settlement. It's a different company now, with a name that has nothing to do with him in it. Every client came with us, every employee stayed. Revenue in the first 2 quarters under sole ownership actually grew, in part, honestly, because the operational chaos of a business run by someone hiding things finally gave way to a business run in the open. I now have an operating agreement I wrote myself with Renata's help, reviewed by a second independent attorney, that spells out ownership so explicitly it would take a team of forensic lawyers to obscure it. I have every account, every filing, every registration under my name, checked and verified twice a year on a calendar reminder I will never let lapse again. Derek served his 90 days. He's on probation. He's permanently barred from managing any registered business entity in our state for a decade. The last I heard, through mutual acquaintances rather than anything I sought out, he's working as an hourly employee for someone else's production company, the very trade he once ran, now something he does for another owner's benefit instead of his own. I don't know how the beachfront relocation with the fresh start worked out for him. I genuinely don't know, and for the first time in a long time, I find I don't particularly need to. If there's one thing I want you to take from this story, It's this: financial abuse and business fraud between partners doesn't always look like a stranger emptying your bank account. Sometimes it looks exactly like trust, exactly like love, exactly like someone handling the boring stuff so you don't have to worry about it. Here are the warning signs, straight from what I lived through and what my attorney told me she sees over and over again in these cases. 1. If you co-own or believe you co-own a business, check your state's Secretary of State Business Registry. It's free, it's public, and it takes 90 seconds. Do it today, not someday. 2. If one partner handles all the paperwork and gets defensive, evasive, or angry when you ask to see the underlying documents, that reaction is data. Healthy business partners don't panic at transparency requests. 3. Check whether you're receiving a K-1 for any business you believe you have ownership in. If you're not and someone else is, that is one of the clearest indicators the IRS and the courts recognize of who actually owns what. 4. Review your insurance policies, vehicle titles, and loan applications tied to any shared business. Third-party paperwork created by people with no stake in deceiving you often tells the truth even when your partner doesn't. 5. If you ever find yourself in a hospital bed, incapacitated, or otherwise unable to actively monitor shared finances, that is exactly the window a bad actor will use. It's an uncomfortable thing to plan for, but consider a durable power of attorney with someone you trust completely, not your business partner, to keep an eye on things during any period you can't. If any part of this story sounded familiar to you, if you've ever had that sinking feeling that something in your business or your marriage's paperwork doesn't add up, please go check today, not next month, today. And if you've been scammed, defrauded, or betrayed financially by someone you trusted, I want to hear about it. Tell me what happened in the comments below. Your story might be the one that helps someone else recognize the warning signs before it's too late for them too. If you made it this far, thank you for watching. Hit subscribe if you want more stories like this one, and I'll see you in the next video.